2, 1.
This Honorable Court of Appeals of Tennessee is now in session.
Thank you, Ms. Lindsay. On behalf of Judges Stafford and Golden, I want to welcome you to the Court of Appeals. We will hear this case just as if we were all in the same courtroom. If we have any technical difficulties, as we did in the last case, we'll stop and try and fix them and go from there. Thank you for participating. Ms. Lindsay, would you call the case, please?
George I. Calzada, MD versus State Volunteer Mutual Insurance Company.
The appellant ready? And you may begin.
Thank you. Appreciate the court's time today. This is an important matter that's before the court. My client, Dr. Calzada, has purchased professional liability insurance. This is the type of insurance that any medical doctor would procure in order to defend themselves and have coverage in place and a defense in place in case any allegations.
Can you identify yourself, sir?
Yes, my apologies. Jonathan Brinson on behalf of the appellant.
Thank you.
And these policies are intended to provide protection to medical professionals where there are any allegations dealing with their medical procedures. In fact, this policy says that it provides coverage in situations where there's a medical incident. In this case, Dr. Calzada had been involved in a lawsuit against his former partners, and as a part of that, out of that lawsuit, the former partners filed counterclaims against him. In those counterclaims, they made allegations, a couple that are most relevant here. One, they said that he committed some protocol deviations that resulted in bad surgical outcomes. Well, it's only doctors that have bad surgical outcomes. They're the ones performing surgeries. You don't have members of a company, you don't have CEOs and directors that perform surgeries. It's doctors that perform surgeries. The counterclaimants go further and allege that Dr. Calzada engaged in medical malpractice, and they actually use that phraseology. Well, the people that commit medical malpractice, again, are doctors. You don't have a CFO of a company committing medical malpractice. That's only in the capacity of being a doctor that happens. And the allegations go further. While they don't specifically name any victims of these, bad surgical outcomes or medical malpractice, it does state that there were infant victims. And in Tennessee, I won't belabor the point, it's notice pleading requirements. They're not required to name who the particular individuals were that may have been harmed from these medical procedures. So Dr. Calzada submitted this claim to his professional liability carrier, and they denied coverage. And the real issue is whether there's a duty to defend here with respect to those allegations. The duty to defend is very broad in Tennessee. The trial court didn't get into the actual case law on that or the actual standard for that. But as long as there is any allegation amongst all of the allegations where there's any possibility of coverage, then the insurance carrier then has the obligation to defend their policyholder as to all of the allegations.
Let me ask you a question. First of all, what is the status of the Shelby County dissolution litigation?
It is still proceeding, Judge Stafford, and there's still discovery that's ongoing. In fact, as part of that discovery, there have been at least one name of one of these infants involved in the allegations of medical malpractice. Again, that's important for this appeal. The court can't take note of that fact because it's not in the record.
Sure.
But it really doesn't matter because the standard is whether or not there's any possibility given the allegations.
Okay, that anticipates my next question, and that's this. Let's assume that the counterclaim is successful. This allegation that he didn't live up to the standard of care. what is the outcome, or what is the likely outcome in that Shelby County litigation? What's the end result of that in this dissolution type situation?
Well, the end result would be there's a likely issue of damages if that's the end result. They have in the counterclaims and the allegations and the prayer for relief as to the counts 5 and 6, which are the counts that we're addressing today, they do ask for damages as a result of that. And so I don't know that there's been...
Are those damages confined to whatever percentage of ownership interest he has in the company?
No, not at all. It's not based on his ownership interest in any way. And while it hasn't been fully fleshed out as far as what the damages would be in the allegations, which again, it's the allegations that matter for purposes of the duty to defend. And the allegations, they refer to damages. They have not only any indemnification damages, what they might owe to any alleged victims, but also reputational damage and harm. And this policy defines damages very broadly. And it defines injury broadly. As injury is defined as any injury, and then it gives several examples, many of which are not bodily injury. It includes reputational harm types of damages. And so that's, to answer your question, Judge Stafford, I'm trying to be more specific, but it's still pretty broad. Unsurprising in these cases, it hasn't developed to a point where the counterclaimants have had to specifically say exactly how much damage is and what those completely entail.
Okay, thank you.
Certainly, and that's important under Tennessee law, and that's why the laws of Tennessee are such that if there's a possibility of damages that are covered by the policy, the carrier has to defend, because you don't know how the facts will develop. You don't know how these depositions are going to go. You don't know what documents are going to come up. And so if there's any chance that there's going to be documents or depositions or testimony that's going to come up that would require coverage and there would be damages, the insurance carrier has to defend from day one. They don't get to sit by on the sidelines and wait until the discovery has developed to a point where they say, okay, well, you've had to defend yourself all along by yourself, but now there's enough, and now we're going to jump in. They have to jump in from the beginning. The lower court here, in finding against Dr. Calzada and saying that there was no, well, the court didn't quite say there was no possibility of coverage. She didn't really use the proper standard, but in saying that there was no coverage here, she relied on two grounds. First, she said that the counterclaims were vague. Well, that's actually supportive of a duty to defend. The vagueness has to be construed in favor of the policyholder, and that vagueness means that if there's any, again, possibility that those vague allegations could fall within coverage, which clearly they do here. They're alleging medical malpractice, they're alleging bad surgical outcomes. That's medical malpractice, that's professional liability, that comes within the coverage provisions. The other grounds that she asserted, that the court asserted it below, was that the allegations did not name an individual. The lower court didn't cite to any policy provision that requires the naming of an individual for coverage to apply. It's just not there. The definition of medical incident doesn't require the naming of an individual. So I'm a little confused as to the lower court's decision of no coverage because it doesn't name an individual. And that type of ruling would create absurd results, because that would mean if a doctor in one situation gets sued and they name who the individuals were, now the insurance carrier has to defend. But if plaintiffs, through no fault of a doctor, decide not to name the individuals under Tennessee's notice pleading standards, and they don't have to in a situation, well, now the doctor doesn't have coverage. Coverage shouldn't depend on what a plaintiff decides to do or not do as far as naming individuals, and the policy doesn't require that. I'd like to briefly address the notice prejudice rule and the timing of the notice here. The insurance carrier has relied upon the Pope case. The Pope case is completely an opposite and does not apply here. It's a very different situation. In a claims made policy, there's two types of notice provisions. One is what I'd like to call it just a claims made notice provision. That's that you have to provide notice of a claim within the policy period or sometime allowed thereafter. And courts have found that this notice provision goes to the heart and the essence of a claims-made policy, which is different than an occurrence policy, which is coverage is based on when something happened, when it occurred. There's a second notice provision that's found in both occurrence-based policies and in claims-made policies. A lot of courts refer to them as the prompt notice provision. Here, it's as soon as practicable is the language. And those are not unique to claims-made policies. They don't go to the essence of a claims-made policy. Several courts have found that the purpose of these provisions is to give the insurance carrier an opportunity to investigate. And it's not about the coverage itself. And so the Pope case was dealing with a situation that was a claims-made policy, and there was no dispute. The claim had been noticed outside of the claims-made notice period. So it went against the essence of the policy itself. And the court easily found and said that it's outside of the period of the coverage itself, and Tennessee Supreme Court hasn't dealt with this, and we're not going to go there. Our situation, there's no dispute. This was reported within the reporting period, the claims-made reporting period. What makes this a claims-made policy? It was reported in that time period. The question now is whether or not the as soon as practical notice language was satisfied. And for that, Tennessee courts should apply the Tennessee Supreme Court's standard of the notice prejudice rule. It's the same as in occurrence policies. There's no reason to apply it to occurrence policies and not to claims-made policies. It's the same provision. And there was it was a federal case, the Fulton Bellows case, and it specifically recognized the Pope case, talked about why it was inapplicable, just as I have now, and it relied on the Prodigy case out of the Supreme Court of Texas, which gave a great analysis for why the notice prejudice rule should apply in these situations, and why here it should be applied not to deny coverage. And the court below did find facts showing why there was no prejudice at all to the carrier here.
Thank you. Your time is up. We'll hear from the appellee. It's just one of you arguing. Is that right?
Yes, Your Honor, I'll be arguing.
Okay. Well, you may proceed when ready.
May it please the court, Lauren Curry on behalf of State Volunteer Mutual Insurance Company. I'm joined today by my partner, Webb Campbell. As we've discussed, there were two motions pending before the trial court. State Volunteer's motion for summary judgment, which is the motion that was granted in full below, as well as plaintiff's motion for judgment on the pleadings. Given the time today, as counsel for Dr. Calzada did, I'll focus on the overlapping issues and on State Volunteer's motion for summary judgment, because it would be dispositive of all issues. Turning to that motion, I'm going to start, as Dr. Calzada's counsel did, with the Shelby County litigation and the request in this litigation for State Volunteer to provide a defense and potential indemnification with regard to the counterclaim that was asserted by CRI and Dr. Calzada's fellow shareholders against Dr. Calzada. As this court knows, when you're looking at the duty to defend, you look at the policy terms and you look at the allegations in the complaint. Neither of those and what they say are in dispute here. There are three different places in the policy where the answer to the question of coverage can be found. I want to start first with that general broad grant of coverage. And for this initial question, where all coverage questions begin, is the burden of the policyholder to show that the claims fall within that first general grant of coverage. And the trial court found that Dr. Calzada did not meet that burden. Specifically, the policy language that we're going to be looking at here provides that State Volunteer shall pay amounts that an insured becomes legally obligated to pay as damages that result from a medical incident. A medical incident is an act or acts by the insured likely to result or do result in damages caused by the rendering of or failure to render professional services to any one person. And that's the language I think that Dr. Calzada's counsel was referencing from the decision below. I'll go through the specific language because words matter here, what was actually alleged in the complaint, but at no point in time does CRI ask to recover damages from the provision of medical services to any one person. And specifically now, Dr. Calzada has conceded that many of the claims asserted against him by CRI do not fall within coverage. Instead, he argues that 2 of those counts could. And one of them is for count 5 of the counterclaim, is for intentional or negligent damage to reputation. And specifically, what is alleged there is that Dr. Calzada engaged in serious billing fraud, inappropriate sexual relations with women who were subordinates and whom he was teaching, and also references a clinical trial contract with a pharmaceutical company that had protocols in it that Dr. Calzada deviated from, that caused a suspension of the contract and caused the potential for a public audit. What is at play there and the damages that are being sought flow from Dr. Calzada's ability to represent his role within the company, to represent CRI, and the damages and his ability to hurt their reputation. Second is count 6, and that is for a declaration for indemnification that Dr. Calzada would have to indemnify CRI should CRI ever be alleged to have damaged somebody else because of malpractice or improper billing conducted by Dr. Calzada. No damages for any, CRI never alleges that there's any claim against it for damages resulting from professional services to any one person there or in count 5. Now, with regard to the reputational harm allegation, I want to address the allegation that the term of injury is so broad, coverage can be found within it. In fact, counsel for Dr. Calzada mentions today what's in the brief as well, that there are certain types of reputational harm that's included in there. And as a first instance, it doesn't matter what kind of harm because none of it is tied to the professional services provided to one person. But regardless, the only specific types of reputational harm included are those that are statements, written or oral, that were provided that were false, libel and slander and defamation. None of those are alleged here to have happened, and no damages flowing from them are sought in this suit. And similarly, count 6 fares no better. At no point does CRI allege that it has had a claim against it, nor does Dr. Calzada allege that a claim has been asserted against him, asking or seeking for the damages flowing from professional services to any one person. What we're looking at here is what are the damages that CRI is seeking? The damages that it is seeking are not those that result from professional services to any one person. CRI doesn't allege it can stand in anybody's shoes to assert those. It doesn't allege that's what it's seeking. And for those reasons, there's no coverage provided. The second location you can go to in the policy here, even if it were to have alleged damages for professional services to any one person, is are there any exclusions or limitations in the policy that would otherwise exclude coverage? And where we stop first is in the exclusions. And specifically, I'm referencing the business enterprise exclusions. And here, those exclude any coverage for claims based on liability against an insured in his or her capacity as a member, partner, owner, shareholder, director, officer of a practice entity. I'm going to sound a little bit repetitive because it builds on the same concept we've discussed here. The reason that Dr. Calzada is alleged to have ruined or harmed the reputation of CRI is because of his capacity as an owner, officer, director, shareholder of CRI. You can see this by reviewing the CRI counterclaim as a whole. You can also see this within counts 5 and 6 itself. Count 5 begins in paragraph 85. Dr. Calzada was one of 2 shareholders, one of 2 directors, president of CRI. And he engaged in all of this conduct, in this sexual predation, in this bad billing activity and fraudulent billing conduct, and in deviating from this important contract for a clinical trial that resulted in a potential public sanction. It was because of how he acted in that role that those damages flowed. Similarly, asking for a declaration after in the face of a potential dissolution of CRI, in the face of these allegations in business divorce, CRI is asking for a declaration that given their relationship, should claims against CRI be asserted for billing fraud, be asserted for anything related to his medical practice, they want a declaration that he will have to stand up and indemnify them. They are not seeking damages for any professional services rendered to any one person. They can't right now. And for that reason, you don't even have to get to exclusions. But even if you do, this is clearly excluded. In business divorces, there's often going to be allegations that somebody took some action in their professional conduct that harmed the other business partner. Simply by referencing that doesn't mean that that is covered by a professional liability policy. Doesn't mean that they're seeking damages that resulted from professional services to any one person. And even if it got past that standard, it's excluded. And this is precisely the reason for these business enterprise exclusions. The third place that you would go in this policy, to see whether or not coverage is available for this specific case is where Dr. Calzada's counsel ended, and that's in the notice provisions. Setting aside the fact that there's not even coverage here, if this even had been a suit that was seeking those damages and it was within the grant of coverage and it was not excluded, an insured cannot seek coverage benefits as if it has failed to comply with certain terms of the policy. Here, those are found in Part 4 of the policy, the general provisions, and specifically in Section 3 there, the notice provisions. We have to begin a little bit sooner because of some of what was discussed in the principal argument. In the general grant of coverage, a claim must be first reported during the policy period. This claims made policy requires that this claim be made in the policy period. There is nothing distinctive about that. Further, there's requirements about the timing of notice. Section 3.1 of Part 4 requires that that a policyholder provide notice of any medical incident to which the policy may apply as soon as practicable from the medical incident. Further, the insured must forward immediately demands, notices, and complaints and summons to state volunteer. And then here's the condition precedent language that eviscerates coverage should you fail to comply with these. And that is in Section 3.5 of Part 4, that state volunteer may terminate any of its obligations expressly referencing the duty to defend and the duty to indemnify. The timeline here is undisputed. At no point in time does Dr. Calzada argue it was reasonable or as soon as practicable. There was no finding by the trial court except a recitation of the arguments as is required in a motion for summary judgment, because the trial court never reached this issue, holding instead on the coverage issue. But should this court reach this third issue, this court has found many times as a matter of law that time periods shorter than 8 months was an unreasonable delay and not as soon as practicable, breaching that provision. And thus, the policyholder had not met its burden of trying to enforce a contract, showing that it had complied with all terms. Specifically here, we have 8 months from when Dr. Calzada got served with the CRI counterclaim. And it is obviously a much greater time period from the time period when any alleged medical incident would have occurred, even if there was one here. So we have a time period this court can rule as a matter of law did not comply with the terms of this policy. Dr. Calzada asked the court below to impose a prejudice requirement here, citing to Texas law. And on appeal, Dr. Calzada points to an Eastern District of Tennessee opinion that did so. And what Dr. Calzada is asking this court to do is to change direction from the original ruling in Alcazar applying a prejudice requirement in occurrence-based policies, the ruling in Pope that said that that would not apply to claims-made policies, even in the face in that case of an argument that that was a hybrid policy that had some occurrence-based and some claims-made elements, which is part of the argument here, I believe. And instead, Dr. Calzada asked this court to open up and to change the direction of jurisprudence in Tennessee to sometimes, well, perhaps he's asking that prejudice be applied to all claims made, but the cases that he cites would ask that it only be applied to those particular hybrid policies that have occurrence-based aspects. Dr. Calzada has not pointed to any term that would have an occurrence-based aspect here. And can't. This is a claims-made policy. And any elements of the occurrence, medical incident here, having to occur after a certain date, we have a reporting endorsement here that backs that up so far to 2006, we don't have as great an impact of that. So this wouldn't be the case anyway. And those Texas cases, and the Eastern District of Tennessee case applied this rule, said if it was reported in the policy year and the occurrence happened in that policy year, there's less of a likelihood of prejudice, so we're going to require an insurer to prove that. We do not have our occurrence, the medical incident, occurring within this policy year. So for that reason, even if this court were inclined to open up its jurisprudence on when to apply prejudice, and there has been prejudice put in the record by state volunteer here, even though it's not required, this is not the case in which such a requirement should be made. I also want to, if I can spend my last 30 seconds, to mention the request for a supplementary benefit for certain state licensure requirements. I want to address a misconception that a potential investigation by CMS is a part of this case. It was not joined below. It's not, relief is not requested in the complaint. Wasn't argued except for state volunteers' objection to IF's inclusion, and it wasn't decided by the court. And those state investigations are not timely within the requirements of the policy, nor are they covered investigations. Thank you.
Thank you very much. Mr. Brinson.
Thank you. Jonathan Brinson again for the plaintiff. Let me address just a few of these the issues that were raised. Counsel for SBMIC is saying that this would be changing course from Alcazar and Pope. It absolutely is not. And to manufacture some distinction about when the occurrence is, and this has a retroactive date of 2006, that's not what these cases are looking at. They're looking at an Alcazar. It was looking at a prompt notice provision, just like the one we're looking at here, the as soon as practical language. Now here, nothing happened in those 8 months. I think it was very reasonable, the reporting period, because nothing was happening except for an answer. But in any event, this Alcazar, its reasoning, its rationale applies to that particular term of a policy. The language that SBMIC is relying upon here, you know, they mentioned part 4. Part 4 is captioned general conditions. This isn't providing notice to a policyholder that this is an exclusion. This is going to terminate your coverage. This is a general condition that's not unique to a claims-made policy. I think language is important in the policy. So, but I do want to look at a couple of the provisions here, and including the damages and the injury. The definition of injury is injury means any injury, including, but not limited to, bodily injury, death, libel, slander, defamation of character, breach of confidentiality, or invasion of privacy. It defines it very broadly, and SBMIC has tried to narrow it even less than what's included here, but the policy made clear it's any type of injury, not even just bodily injury. Damages is similarly broad, and it says that damages means all amounts of money that are payable pursuant to a judgment or a settlement approved by the company because of injury to which this policy applies. So it isn't even that the injury itself is the damages. It says any damages that result because of injury. And injury is incredibly broad. If you look at the definition of a medical incident, again, a single act or omission or a series of related acts or omissions by insured that results or is likely to result in damages caused by the rendering of or failure to render professional services to any one person. Now, SMI misstated that it says damages to any one person. That's not what it says. It says damages caused by services to any one person. And I guess the position that the carrier is now taking is that there would be coverage if it was one named person, but since it says that there were multiple infant victims, there is no coverage because that's not just one person. I don't think that's a correct reading of the policy. I don't think that's what it intended, and it's not the reasonable expectations of any policyholder. If each of those is a separate medical incident, that's fine, but each one of those alleged victims is an individual. When they say that real briefly here, when counsel for SMIC says that they're simply seeking a declaration, that is not accurate. In the prayer for relief, what we're looking at on the amended counterclaims, the prayer for relief, what we're looking at is counterclaims 5 and 6. In their prayer for relief, paragraph 5, they ask for a rule that defendant CRI is entitled to damages regarding counterclaim 5 and an amount to be proven at trial. That's not a declaration. Number 6 is a request that the court rule that defendant CRI is entitled to damages regarding counterclaim 6 in an amount as of May 31, 2019 to be proven at trial. Then they also ask for a separate count a declaratory judgment.
Thank you. Thanks to both of you, all of you. Ms. Lindsay, would you recess the court?
This Honorable Court of Appeals is in recess until 1 p.m.
You may leave now.
Thank you all.